And now I'm joined by Joe Morris, who was a senior official in the Reagan administration and is now president of the United Republic Fund of Illinois. He's a partner in the law firm of Morris, Rathnow, and De La Rosa. Maureen Murphy, who is a commissioner with the Cook County Board of Review. She's a former Republican state senator and a member of Illinois Women for Bush. Barack Obama, joining us again, a Democratic state senator representing the 13th District. He teaches constitutional and voting rights law at the University of Chicago. And Martin Castro, a Democratic activist and vice president with Juritas.com, a company which provides legal briefs online. Did I pronounce the name of your country?
Juritas.com.
Juritas.com. Okay, thank you very much.
Well, let me first say I agree with Joe about how the federal courts are going to respond. I think that the federal courts have no business being involved in this. This is a state court matter, unless there's some showing that, in fact, a Voting Rights Act or federal right has been violated. And frankly, I don't think that some of the complaints that have been generated can be elevated to that level. I think that Joe's mistaken, though, when you look at Florida law with respect to this 5 p.m. deadline. There is, in fact, ambiguity. I went online and pulled the election laws of Florida and looked, and in fact, in essentially the same section, you have contradictory edicts in these statutes. You've got one statute that's saying the Secretary of State shall adhere to this 5 p.m. deadline, and then you have another statute that says, another section of basically the same statute saying she may adhere to the same to this 5 p.m. deadline.
So you're suggesting there's some wiggle room that lawyers could conceivably argue this is an instance. Well, for example, they also raise the possibility that when there's a natural disaster,
exactly,
that the Secretary of State might have some flexibility. It's not reflected in the statute.
That's happened before, and I think but I think Joe's right that will be determined by, ultimately, I suspect, the Florida State Supreme Court. I think the Florida State Supreme Court will be confronted with this decision. Does the Secretary of State have the final authority to make this determination, or can that be overridden because of the extraordinary circumstances we're confronting here?
Yes.
What's interesting about the Bush strategy up until this point has been that they decided to go into federal court making equal protection claims and due process claims under federal law that I don't think necessarily really pan out. I think what the Bush campaign could have done is go into state court and argue that, look, it's not fair for Democratic counties alone to be counted. We understand that there's this 72-hour deadline whereby, you're supposed to introduce this recount. We determined not to do that, but now when we're seeing essentially the Democrats are boosting their turnout effectively, we think we should have that same opportunity.
Joe
that
Morris,
would have been that would have been a legitimate argument, but that's not the one that they've made.
Why didn't they make that argument,
Well,
Joe Morris?
with all due respect to Barack Obama, the only thing which you just said with which I disagree is the suggestion that there is a Bush strategy. In a way, in a very real way, what exists here is the absence of a Bush political strategy. The thing that concerns me the most about the political strategy that's been followed by the Gore campaign in this post-election trauma is what clearly is an effort to demonize the existing constitutional process. To put it...
Okay, let's get a reaction to that.
I've got to react to a couple of things. Now, it's true that we're not alleging fraud, but it's also true that the process of a recount, whether it's by machine or by hand, is also done regularly throughout the process. I mean, I'm in the state Senate. We had a couple of state Senate races that were won by 87 votes or 137 votes. And it's standard procedure to seek a recount when it's that close. What's unusual, the only thing unusual about this recount process, whether it's by hand or by machine, and these various maneuverings and controversies surrounding it, is it rarely happens in a presidential election, not in our living memory. So the notion of having a hand recount or a machine recount, which the Bush administration has been characterizing as stalling or tactics or politics or litigation, in fact, is a very standard process to try to get a more accurate count when you've got a very close election. And so I think there's nothing wrong with it.
And under Florida law, the rule is attempting to discern the voter's intent.
Which it's very clear in Florida law. It's been used. In fact, the hand recount was actually utilized by Republicans in one of their counties, in Seminole County, I believe, in this very election.